Whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the Court. Jessica Snyder on behalf of the appellant Maisha Taylor, and I'd like to reserve 3 minutes of my time for rebuttal.
Sure, just keep track of your time, please.
Thank you, Your Honor.
You bet.
In the face of a 5-count federal indictment, Maisha Taylor exercised her right to a jury trial and was acquitted of the majority of the counts against her. The district court's sentencing decisions disregarded the jury's verdict and diminished Ms. Taylor's jury trial rights. Recognizing that I have limited time and many issues today, I'd like to start by talking about the 2 sentencing errors that implicated Ms. Taylor's constitutional jury trial rights, and then I'll proceed to the prosecutorial misconduct or be otherwise directed as I can be helpful to this court.
Okay.
So starting with the acquitted conduct, the record here confirms that Ms. Taylor's sentence was increased based on the acquitted counts, not based on the hung count, and that's for a couple of reasons here.
Even if we buy that, even if you persuade us of that, could you go to the other problem, which is the Mercado case and the date of the effective date of the change?
Absolutely, Your Honor. So I think there's 2 questions there. The most important, I believe, is this court's path under Miller v. Gammy to making the determination that there's sufficient intervening authority that undercuts the reasoning and theory of the Mercado majority case to allow this court to not be bound by it. And I want to touch on that first.
Okay.
So the circumstances of this case are incredibly unique. What we have here is the Mercado's majority opinion resting its reasoning on the fact that it thinks that the Supreme Court had decided the Sixth Amendment issue in Watts. And that is what we know from intervening authority to be undermined at this point. And what we have here, which is unique, is both written opinions by many Supreme Court justices specifically speaking to this issue and action by the Sentencing Commission and their reasoning and their action adopted.
Do we have an opinion of the Supreme Court that rejects the use of acquitted conduct?
Your Honor, we don't have one that comes after Mercado. What we have...
And the Sentencing Commission wouldn't have done what it did, or wouldn't have needed to if the Supreme Court had ruled otherwise, right?
That's right, Your Honor. That's right.
Right. So they haven't got, several of them have lamented the state of using acquitted conduct, but I think that's why the Sentencing Commission took its action. I take Judge Hurwitz's point.
Yeah, the commission said, well, we might change it, but we're not backing it up. We're not making it retroactive.
Well, but 2 points, right? One is that they had to act because the Supreme Court didn't have a majority, and then there's the other question, which is the retroactivity.
The part that's undermined, Your Honor, by an actual Supreme Court case, but I will note that this predates the Mercado's opinion, is the fact that the Mercado majority thought they were bound by the Watts decision and that the Supreme Court had decided the Sixth Amendment issue and that it said it was permissible under the Sixth Amendment to sentence under acquitted conduct. What we know from Booker and from all of the writings of the Supreme Court since that time is that the Supreme Court does not believe they've decided the Sixth Amendment issue.
It has to be an intervene, according to Massey, what's it? Gammy.
Miller versus Gammy.
Miller versus, I keep thinking of the congressman. Miller versus Gammy, it has to be an intervening Supreme Court decision.
That's correct, Your
In
Honor.
other words, we may have got the law entirely wrong at the time, but we're still stuck with our prior decision unless there's something new that tells us.
What we have here...
Was that a yes? Do you agree with that? Or
I do agree. I think that the Miller v. Gammy path requires intervening authority that undermines the reasoning or theory.
Okay.
It doesn't have to be a holding that squarely rejects.
I'm not trying to sidetrack you. I just want to make sure you agree with the premise. Go right ahead, please.
Yeah, what I was going to say, Your Honor, is that while we don't... I don't have a Ninth Circuit case that says that this is permissible. This is different from the other circumstances I've seen Miller v. Gammy approved. But what we have here is intervening action by the Sentencing Commission and written statements by 5 Supreme Court justices. To the extent this court doesn't think that's sufficiently binding on this court or sufficiently evidence that the reasoning in the Mercado majority is undermined and wrong, then I would urge this court to refer this issue to the en banc panel for review.
Or you can file a petition for a hearing en banc.
Can I just back up a minute? Then you're asking us to look at this change in the sentencing from the Sentencing Commission as intervening authority.
Yes,
And it
Your
would have to be and meet the Miller versus Gammy standard under your theory, which was, it has to be irreconcilable. And at a minimum, it's not retroactive, right?
Reasoning is what's irreconcilable, Your Honor. The reasoning is, and I agree with Your Honor, it's not retroactive. The reasoning is that the Mercado opinion is based on the premise that the Supreme Court has decided that acquitted conduct sentencing does not violate the Sixth
I
Amendment.
know that. I appreciate that. But what I'm trying to get at is if you're relying on action by the Sentencing Commission to be your intervening event, I guess we'll call it, right? That surely that didn't become effective or hadn't become effective as of the date of this sentencing. So that event, that change from the Sentencing Commission wasn't operative yet.
No, Your Honor, that's more relevant to this court considering whether or not it has a path under Miller v. Gammy, not what the district court should have applied.
I don't know because this is a bit of a mind teaser to adopt the path. I don't think we've ever done this, have we?
Your Honor, I could not find a case. I found cases where the Supreme Court has reasoned about other issues in an actual case that this court has then said was sufficient without having the holding overturned.
Okay.
I have not found a case that mirrors this.
Well, Judge Hurwitz and I have taken up a lot of your time on this.
Have you found a case that says that the Sentencing Commission's statements can be intervening authority?
Not specific to the Sentencing Commission, there have been agency actions that have been considered intervening authority in other contexts.
So
Go right ahead, please.
The government argues that she wasn't sentenced based on acquitted conduct, but based on a hung jury. So how do you respond to that?
Thank you, Your Honor. I think the record makes this clear for a couple of reasons, that Ms. Taylor was sentenced based on acquitted conduct, not based on the hung count. The first is the district court's sentencing language itself, looking to the words of what he held in his sentencing ruling, which was the offense level is, quote, then increased by 4 points for the possession of a firearm in connection with drug distribution. Drug distribution is most parallel to count 3, one of the acquitted counts, which was distribution of cocaine. The government argued that the court in its sentencing materials, and the PSR did the same, that the court could apply this enhancement based on possession of cocaine with intent to distribute, the hung count, or drug distribution. The court used the word drug distribution. That associates with count 3. And the oral argument at sentencing only further supports that the court was making this consideration. The judge asked specifically the government if it could consider the evidence submitted at trial relating to the acquitted counts, specifically referencing count 5, which was possession of a firearm in furtherance of drug trafficking, and said, my standard's different. I consider preponderance of the evidence as opposed to beyond a reasonable doubt. So he specifically asked about that course, and then his ruling, he used the words drug distribution.
You've used about half your time now on this, on trying to convince us that our prior decisions are wrong, and I'm sympathetic to it, but let's assume for a moment that we think we're stuck with our prior decisions, and you can move to have us reconsider them in bank. I'd be interested in you addressing the obstruction of justice enhancement and tell me why you think that was improperly applied.
Thank you, Your Honor. I want to start by talking about the obstruction of justice enhancement relating to this court's 2 most recent opinions on point, the Williams case and the Ho Romero case, which were decided this year and addressed in our 28J letters. In order, what this court has said recently, reiterating prior reasoning and precedent, is that in order to find the obstruction of justice enhancement based on a defendant's trial testimony, that the sentencing court must explicitly find that the perjury was for the purpose of obstructing justice.
That's the willfulness.
That's the willfulness, Your Honor.
So are you contending that there's not sufficient evidence to establish willfulness, or are you just contending that the judge never made the appropriate finding?
Both, Your Honor.
Well, I'd like to direct you to the first one, because whatever other significance we give to the colloquy between counsel and the court about she knew she was under supervision, I think there's probably enough evidence for a judge to conclude by a preponderance of the evidence that she knew she was lying. My question is a different one. Did the judge actually make the finding? And if he did, or she did, I forgot who the judge was. He did. Why was it sufficient? Why was it insufficient?
Your Honor, the judge did not make the finding that it was for the purpose of obstructing justice here. And the Ho Romero and Williams cases talk about just very quickly, I want to mention Ho Romero specifically talks about the harmless error standard in this context and is very relevant. But turning to the actual finding that was made, the court said, quote, "I do find an increased level of 2 is appropriate for obstruction, primarily based on the expungement testimony." The prosecutor at the end of the sentencing ruling
I
then
think
asked,
the government recognized, May Judge, you haven't
Yes.
said willfulness. So, are you finding willfulness and materiality? And the judge said, yes,
yes,
I
with
am.
respect to expungement. Putting aside whether that is sufficient for finding willfulness, what this court has said is that in Ho Romero and Williams, is that in order to find willfulness, there must be an explicit finding, explicit with specificity, that the perjury was for the purpose of obstructing justice.
Now, let me ask you what the judge then said thereafter and see whether or not why you think that wasn't enough. Because the judge essentially said after that, essentially based on the fact that she gave this testimony right after the juror asked the question. Does that establish willfulness, or does it only establish materiality?
What he said right after the prosecutor asked was, with respect to expungement, yes.
Right. But he said a little bit more. He said, with respect to expungement, and then I have his exact words here, but we don't have to quote him. He basically said, because it was given right after the juror question. And so I'm asking you whether that's a finding of willfulness or materiality. My sense is it's a finding of materiality, but not necessarily of willfulness.
I think that's right, Your Honor, especially in light in this court's requirement of an explicit finding that it was for the purpose of obstructing justice.
But I'm sorry to interrupt you, but I will give you the quote because I happen to have it pulled up. The district judge then said the findings are based on the fact that her testimony did come fairly shortly after one of the juror questions asked about expungement. So I'm not sure how the timing of what she said relates to whether it was material. I mean, whether it had the possibility of impacting the verdict, right? That's the materiality. And if she said it, right after the question from the juror or a significant time later, still that doesn't seem to reflect materiality. It seems to go to whether she did it with intention, whether she was massaging her testimony, changing her testimony in response to the question so that she could try to influence the verdict.
2 quick responses, Your Honor. First, I think that this court has required specificity and explicit findings.
So you also have to keep in mind that our case law must be reconciled with Dunning, which is the Supreme Court's decision on this very issue. We can't overrule it. And so our case law has to be interpreted to be consistent with what the Supreme Court has said on this issue. And the court has said it's preferable for the district court to address each element of the alleged perjury in separate and clear findings. But it's sufficient, it says more, I quote, "A determination that enhancement is required is sufficient, however, if the court makes a finding of an obstruction or an impediment to justice that encompasses all the factual predicates for a finding of perjury." So I don't read that to mean that there are magic words required, that the district judge has to say the words intent, purposeful, willful, material. It just has to make the findings that encompass the elements of the perjury.
A really quick factual clarification, and then I do want to save the remaining time for rebuttal. In this case, what happened after the jury question is that the prosecutor asked Ms. Taylor about expungement explicitly. The prosecutor initiated this. She said...
But she still testified under oath.
And she said, it's true, you've never applied to have this expunged. That was the question.
Counsel, now you're talking about whether the judge could have made the finding, whether the record supported the finding. But I understood. So I'm a little confused about your argument because I don't hear anybody. Well, I'll just speak for myself. I take your point about the record, and I think I take Judge Hurwitz's point that the record would have supported, I think could have supported such a finding. But I understand your argument to be, and this is why you're causing me some confusion, that under Ho versus Romero, we have said, and quite recently, in perjury cases, the express requirement for a finding of willful intent means the intent to obstruct justice. And we've reiterated, as I said, very, very recently, the earlier statement that it has to be an explicit express finding. So in response, I'm not sure you're really grappling with Judge Beatty's question, which is asking you whether we're bound by this circuit precedent or by the United States Supreme Court precedent.
And I'm sorry, Your Honor, I'm getting distracted by that fact because it's been kind of incorrectly characterized.
Well, let's
Yes,
get to
putting
it.
That
Let's
aside.
get to it.
Yes, Your Honor.
What are we bound by?
I think the requirement for the explicit finding is absolutely required by this court's precedent. I don't think that's inconsistent with the Supreme Court, and I think it's because of the fundamental concern about chilling defense opportunity to testify on their own behalf, the fact that we need a clear record on this. And I know I'm over my
Before
time.
you sit down, I think this is an easy yes or no question. I read
But
your
you
brief.
say that a lot.
I know,
and it's not.
it turns out not to be.
Yeah,
But
but
I
give your
think
best
your
shot.
brief only challenges the absence of a finding on willfulness. Am I wrong about that?
I think Your Honor, I will verify the answer to this
Okay, fair
in my
enough.
rebuttal.
Fair enough.
Hang on, we've got one more
I'm going
question.
to ask you another
Yes.
question, and Judge Kristen's very kind and generous. I'm sure she'll give you some time for rebuttal. Now I've lost my train of thought. Oh, if we were to agree with you and return the case for resentencing, which guidelines would apply?
Your Honor, my understanding is that the current guidelines at the time of the resentencing would apply, so Guideline 826 would apply in this case.
Okay. When you come back, we'll put 2 minutes on the clock. We took a lot of your time.
Good morning, Your Honors. May it please the Court. Sarah Barr appearing on behalf of the United States.
Can I interrupt you right at the top? I guess I just did. My understanding is if we send this back for resentencing, it's a do-over with the guidelines that were in effect at the time. Is that wrong?
I think that's wrong, Your Honor. I thought that too and looked it up yesterday, and I believe it will be the new guidelines in effect now. However,
What's your authority for that?
my authority is in an email that I sent somebody else and didn't jot down for myself.
Okay.
But I would be happy to provide it to the Court in a supplemental briefing.
Okay, I might
afterwards.
actually take you up on that. We get those offers all the time, and we say, yeah. Except I would like that authority. So go right
Absolutely.
ahead.
I will be sure to do that. But and I'll just sort of add, I don't think that the result would be any different because even if the court relied on the acquitted distribution conduct, that conduct is almost entirely coextensive with the possession with intent to distribute conduct, which was not acquitted.
I'm a lot more concerned about the obstruction
Let's move on.
and perjury, and I'm not so sure that wouldn't make a difference. I don't know.
Okay, great.
But do you have the same position vis-a-vis that? Because I think that added 2 points to the guideline calculation.
I'm sorry, I'm not sure I'm understanding your question.
My most concern, I'm just one of three, but the thing that I'm most concerned about on this sentencing is the perjury finding,
Okay,
and
got
or the lack thereof. And so I don't take your argument or your statement to mean that you're saying that wouldn't make a difference or requires resentencing.
Correct.
Yeah. Okay.
Yes,
All right.
absolutely. I'm
It
sorry.
would,
I
it would
didn't
still
understand.
be a two, if it were found,
2
it would
points.
still be a 2-point enhancement.
Yes.
The base might be different under the new
Yes.
guidelines.
Well,
I don't think that's right.
base would be the same because of the arson.
Right, so that's why I'm trying to figure out what your answer to Judge.
Okay, now we're
Kristen's
saying
question.
3 different things. How about if you go on with your argument, and it sounds like we need to get but it's a yes/no answer that we'll get to about which set of guidelines would apply on remand. So if we remand, how's that? Okay, go right ahead.
Okay, so regarding perjury, I think there's no dispute that the case law says that there must be an explicit finding. There is no case law that says what the form of that finding must be.
Can I stop you there just because you're I know I just said I wouldn't do that, but you seem to be conceding the point there's a finding or a requirement of an explicit finding. Are you relying on Ninth Circuit authority, or could you go back to Judge Beatty's exchange with your friend?
Sure.
Ninth Circuit authority or Supreme Court authority?
Supreme Court authority. I think the Ninth Circuit authority is consistent with the Supreme Court authority. I agree there's no magic words. There needs to be an explicit finding. There need to be words.
Okay.
Enough words.
So okay, thank you. And so in this case, was there a finding of do we have all the findings that we need? In particular, we're concerned about willfulness. At least seems like that's where you're getting the questions.
Yes, there was a finding in two ways. First, the court explicitly confirmed to the prosecutor, yes, I am finding willfulness pursuant to the expungement testimony specifically.
Well, he didn't say that. He didn't say, yes, I am finding willfulness.
He said yes when the prosecutor asked, are you finding the expungement testimony to be willful and material?
Did the judge ever utter the word willfulness?
The judge himself did not utter it. What he did in addition to state those explicit words on the record was clearly adopt the government sentencing memo, which contains extensive analysis, citations to the record, citations to this court's case law, citations to the USSG manual. There are timestamp references and quotations to the exact testimony that the government was arguing was perjury.
And I don't think there's any question that the finding would have been supported here. That's just on my scorecard. Maybe Judge Hurwitz disagrees with me. My question is whether or not the finding was made. Go right ahead.
Yeah, that's what I want to focus on what you had to say. One of the reasons we need a finding, whether it's in magic words or otherwise, is to review the basis for it. And at least in terms of the sentencing, the judge never made a finding of willfulness until the government prompted him.
Correct.
You agree?
Yes.
And if the government had never prompted him, we would have error, would we not?
I don't think so, because we still have the adoption of the government sentencing memo, but it would be a different conversation.
It'd be harder. Okay. Yeah. So he now says yes to the government's question. And then he says, and as to the expungement, Judge Beatty read you the words before, but essentially was because it came right after
the juror's question.
Correct.
I'm trying to figure out why that supports willfulness. Because remember, the defense of Ms. Taylor was, yeah, I was wrong. I thought the expungement of an eviction or some other thing really constituted expungement of the crime. I might not believe her, but I'm not the finder of fact. But doesn't the judge at least have to address her defense and say why I don't believe it?
He needs to find that it was willful. And I don't
know. But is it enough just to say willful when she's posed a very specific defense? This wasn't willful because I was honestly mistaken. If I were the trial judge, based on this record, I would reject that in a minute. But I'm not the trial judge. And the trial judge didn't reject that. What he said was it occurred in close proximity to the juror question. And I don't find that as having I'd like a finding by the trial judge that she wasn't telling that she was willful, and I'm not sure I can find one.
Sure. If I may answer that in two ways. Number one, I would point you to, the testimony on, not the testimony, the colloquy between the parties and the court about what to do about the jury note. Right. And during that colloquy, where the defendant was sitting right there listening to the whole thing, the court suggested, well, I don't see expungement is relevant in this case, so I'm inclined to tell the jurors it's not relevant. And the government,
I think it wasn't.
And the government said, hold on a minute, hold on. There might be some relevance here, because if her conviction was expunged, then she's not guilty on counts 1 and 2, right? The defendant is hearing the government say that. If the conviction is expunged, she's not guilty on counts 1 and 2.
Well, let's put aside whether that's correct, but go on.
Right. But that's what was said, and that's what the defendant heard. And then she went up and testified to clear falsities that her federal conviction, that all of her convictions were expunged.
That was false. We all agree that was false.
I think that...
but why does the close proximity establish that she just wasn't mistaken?
I think under a preponderance of the evidence standard, the court could make a rational inference that the proximity made it willful. It was also different.
See, that's what I'm having trouble with. Why does the proximity make it willful? the proximity, I don't think it's material at all, but nobody seems to be fighting about that. But why does the proximity make it willful?
I may be misspeaking when I say proximity. I think really what's more important is the sequence. It's really more the sequence, the fact that it came after. And the judge used the term proximity, but I think in the context of the government sentencing memo, in the procedural history of the trial.
Can we also look at, I'm sorry to interrupt you, but earlier in the colloquy, there was an exchange between the judge and I believe it was defense counsel, and defense counsel was arguing it wasn't a knowing misstatement because Oregon's been changing its laws with respect to expungement. And the district judge said, but wait a minute, I have this defendant on supervision for a prior felony. She's been under my supervision. She knows that this hasn't been expunged because she's still under supervision. So that seemed to be another really explicit part that happened during the sentencing colloquy where the district judge was making statements, findings of fact about willfulness.
I agree with you, Your Honor. That shows what the court was thinking in its mind, and I think that's relevant. I think
But the problem is that our problem is that our precedent requires an explicit finding, and we've said this for decades now, over and over again. And we've also mused, I think, on the record about whether that requirement is strictly necessary. But it is our precedent, and you don't seem to be pushing back on that. My concern is that this exchange that we're having here today seems to be exactly why we've required these explicit findings, because you've got, I think, persuasive, strong arguments about what the judge must have been thinking. And I'm not pushing back on whether the record would have required it, but there's an important First Amendment, the policy reason for the precedent in the first place that I want to reiterate and take your time with that. But isn't this the rub? Isn't this why we have this requirement?
Absolutely. I absolutely agree with you, Your Honor. And I think that this case would be much harder for us if we didn't also have the court unequivocally say 4 different times that it was adopting the government sentencing memo and, quote, all of the reasons contained in it as thorough and correct.
Okay, so I think that's a strong argument for you. But if we go that route, it just seems to me that we disregard our own precedent that uses the word explicit. And then, of course, this Hobo versus Ramirez case, which is 2026, very recent case, reiterates that. So help me reconcile those two things, please.
I don't think it's disregarding your precedent. Like I said, I think what the precedent is very concerned with is the substance of the findings that must be made. It must be findings of falsity, of materiality, and willfulness.
But do those words, I think that's the difference that probably Judge Kristen and I have in approaching this is explicit findings. When I read Dunning, it says there must be a finding that encompasses all the factual predicates of perjury. But I don't read it to mean the word willful, the word material, the word falsity, that those actual words have to be uttered. The district judge has to say enough that we know that he or she has reached factual findings that support the elements of perjury.
I agree with that.
Do you agree that that can be squared with our precedent?
I do. This court has plenty of precedent.
Well, what do you think explicit means? Maybe that's it. Maybe we think explicit is a different thing. I'm not trying to be flippant saying that.
I think you're right. I think you're right.
Okay.
I think explicit means words that allow this court to know whether it is making a finding related to the substance of these elements. And those words can be, I adopt the government sentencing memo for all the reasons contained in the sentencing memo.
Could they be, I adopt the pre-sentence report?
If the,
They can't, can they? There's cases that say it's not enough to rely on the pre-sentence report.
Well, I disagree with you on that. They don't say that it's the pre-sentence report in that context it's insufficient to, as an example of explicitness. They say the substance of the pre-sentence report was insufficient there. So I think if the pre-sentence report
So why isn't the substance of the government's sentencing memo also insufficient to establish?
So the problem with the PSRs in various cases has been it didn't cite the trial testimony, or it didn't make findings on willfulness or materiality. There were no facts. It was just insufficiently supporting one or more of the substantive elements. So we would argue in that case, or we would agree in that case, the court made an explicit finding, but the finding was insufficient because the PSR doesn't contain enough information required for all three substantive findings. But that's not what we have here, because we have the government sentencing memo that is 18 pages, extremely thorough and comprehensive, citing all of the facts, all of the record, all of the case law.
Beyond that, beyond the memo, I would, and I worked in a trial court, so I assume this happens here in trial courts as well, that something happens and the attorneys from one side or the other stand up and prompt the court to avoid reversible error, to avoid an error on the record. Your Honor, you forgot to, did you intend to allow the defendant to speak? Did you mean that finding, were you making a finding, things like that, which seem to me perfectly acceptable and reasonable so that we don't have needless appeals if something can be addressed on the spot. So I guess the implication of, Your Honor, are you making a finding of willfulness and materiality? Yes, in my view, would be the same as, yes, I find it was material and willful, if the judge had said those words. Is that consistent with what you think happened here and what happens in district court in Oregon?
Yes.
So let me just play with that scenario a moment, see what your position is. Let's assume that we just get to the end. The judge says, I'm going to apply the obstruction, the enhancement for obstruction. Doesn't say why. The government, by the way, no criticism of the government here, did exactly what it was supposed to do. Said, Judge, I think you forgot to address willfulness and materiality. And the judge says, yes, I find willfulness and materiality. Says nothing else. Would we sustain that? Simply because the record might well support his conclusion, don't we need some basis for his conclusion to review?
So what you need is enough of an explanation to satisfy you.
We need some kind of explanation,
that he's considered the parties' arguments and has a reasoned basis for exercising his
and
legal
so your view
decision-making.
is that the adoption of the government sentencing memorandum provides the explanation.
Absolutely. I don't know that we would be here if what the court had done was just copied and pasted the government sentencing memo and put it in a written decision and issued it.
Counsel, I'm going to stop you there and but add a minute to your. Just keep rolling. I'm going to give you another minute or two to because we've taken so much of your time on one issue. Can you please address the Mercado issue? I mean, unless you don't want to. I just wanted to give you an opportunity.
Yes, no, I'm happy to address it. Does the court have a specific question?
I'm concerned about the fact that our case law is what it is. Our precedent was what it was, I guess I should say. And the sentencing guidelines had been amended, but they hadn't been, the new effective date hadn't triggered those guidelines yet. And opposing counsel has got a theory about why the Sentencing Commission's action can be treated for Miller versus Gammy purposes as undermining. I'm not paraphrasing very well, as undermining, so that new rule should apply here.
Sure, I think there may be a set of circumstances where that theory would be valid. I don't think it's this case, particularly because I do think it matters that the Sentencing Commission did not make it retroactive. And so as a matter of policy, it did not find it needed to correct these issues that it wanted to change going forward.
But at the top of the hour, so to speak, you said that if we send this back, the new set of guidelines apply?
I think it does, but again, I don't think, and I will double check and send the case law that I found.
What's tricky, of course, is the case law. Much of the case law talks about the guidelines that are in effect on the day of the sentencing apply. But when you send it back, of course, I think I want that specific. And I thought that's what we had checked, but maybe we got it wrong. That's something we'll need to follow up on. But be that as it may, I think Mercado remained although many people had lamented it. Do you agree that with Judge Hurwitz's question, when we walked down that path, that the United States Supreme Court doesn't have, never had a majority on that point?
That's correct.
Okay. Do you have more questions on that? Do you have questions? No. Okay. Thank you.
Thank you.
Thank you, Your Honor. To first very quickly answer Judge Hurwitz's question, I do think the way we raised the issue on obstruction is we did challenge all of the required court's findings in our opening brief. So just to resolve that issue, I want to talk about why the court's blanket reference, positive reference, and agreement with the PSR and the sentencing memo aren't sufficient to satisfy this court's precedent for explicit and specific findings in the obstruction of justice context. So this court addressed this issue in Williams. In that case, for the PSR, the court adopted the PSR pursuant to for the obstruction.
Washington decisions. Now in session, all for the court, John, the Honorable J. Simpson presiding.
Maybe see.
Good morning, Your Honor. Raymond for the people. Your Honor, people waive any conflict between this honorable court and the office of public defender. While the people do not believe that any such conflict like this, we believe waiver and avoidance of all doubt.
Good luck.
Good morning, Your Honor. Assistant Public Defender Nicholas Bukovich. Likewise, we do not believe a conflict exists between this honorable court and the Office of the Public Defender. However, one does advise we would waive it.
And the court, for its part, also does not believe there's conflict either of the Michigan court rules or the cases decided thereunder. To the extent a conflict may exist, given the waivers, the court will consent to hear the matters. The court calls the case People versus Carla Bristow.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Alexander Hermanowski with and on behalf Carla Bristow. Carla, please unmute yourself in your video and state your name for the record.
Carla Bristow.
Thank you. All right, what are we doing?
Your Honor, this is a case that we've been adjourning for some time in order to work out some potential resolutions outside of criminal resolution. Unfortunately, part of that involves conversations that I be having with some law enforcement. I was scheduled to have that conversation last weekend, but unfortunately things fell through and I was not able to have a conversation, for which I'm deeply apologetic. But I would be requesting another adjournment to see if we can get another one scheduled so I can have that meeting and see if we can ultimately resolve this case. Again, this is something that's on me. Mr. Hermanowski has been quite diligent and it fell through on my end.
Oh, don't do that. Blame Hermanowski. No, I'm kidding. All right. Is there any objection?
Good, how are you?
Really? Was that Barnwell? Anyway, Mr. Hermanowski, there's no objection to the adjournment.
No objection.
All right. What's my date?
July 1st.
Will that be enough time for you, July 1st?
I'm hoping so, Your Honor.
All right. I'll adjourn this matter July 1st, 2026, 9 a.m.
Thank you.
Okay. You guys
Thank you.
have my information, right? I'm in the Hope House.
Yeah, I have that information.
Yeah. Yep. They do. All right. Thank you.
Thank you.
Thank you.
Bye.
Court calls case People versus Brianna Force.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Wendy Barnwell on behalf of Miss Force. The unfortunate thing is I'm in a center, but here I am.
Okay. All right.
I don't think he could.
You broke up there for a moment.
Yeah, I'm in an elevator in the CJC in Detroit, but I should reach my.
Got none of that last part. Mr. Let me. Okay, we lost you there. We don't have your client, Miss Barnwell.
Okay.
Miss Barnwell, why don't I pass the case? Yes. We'll call you back up momentarily.
Right. I will call her again.
All right. Thank you.
All right. Thank you. Thank you. Sorry about that.
Not a problem. Court calls case People versus Andrew Newman.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Brian Fennick appearing on behalf of the defendant, Dr. Andrew Newman, who appears to my right. Will you please state your name for the record?
Andrew Newman, Your Honor. Thank you. As to the arraignment.
Your Honor, having been fully advised of the charges against him and the possible penalties, my client waives a formal reading and stands mute.
Pending having waived formal reading, standing mute. Court will enter a not guilty plea. And what are we doing on this today?
Your Honor, respectfully, my client is a professor of anthropology. He is has a pre-planned trip to Europe this summer for research for a book that he's writing. We are respectfully requesting permission to travel as a bond condition. But Your Honor, my client, as to bond, my client has numerous ties to the community. He is He's resided in Ann Arbor for decades. He retained me immediately after his arrest. He is not a flight risk, Your Honor. He's not a danger to the community. We're respectfully requesting a personal bond.
All right. So you'd like to be AC in this matter?
0.155, there were no fresh and no priors to the people's knowledge.
And you're just asking for an adjournment of the pretrial?
Your Honor, as to the pretrial, we are asking for an adjournment. However, he does not return to the country until the end of August, or sorry, the end of July, excuse me. So we could be available the 27th or 28th of July, or
So, all right, okay, I got it. But give me my first date in August. I'll adjourn the pretrial on this matter to August 5th, 2026, 9 a.m. Set the defendant's bond in an amount of $15,000 personal recognizance bond. All other standard conditions, including no assault behavior or possession of any weapons or ammunition. There's also to be no use of any alcohol, recreational marijuana, or any illegal drugs. I am going to order that the defendant report to the Department of Community Corrections for placement on a SoberLink testing device through Community Corrections. I will indicate that the defendant may travel. Where he's going to Europe, is that?
yes, Your Honor, France and Great Britain.
And what are departure and return dates?
July 6th through July 26th.
July 6th, 2026 through July 26th, 2026.
Yeah. And that includes your return dates, correct?
Yes, Your Honor.
All right. I'll indicate the defendant may travel to Europe July 6th through July 26th, 2026. All right. Anything further?
Nothing further, Your Honor. Thank you.
All right. Thank you. Well, court calls the case of the People versus Kenneth Tucker.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. On behalf of Mr. Kenneth Tucker, Attorney Nicholas North, PH 6482. Mr. Tucker, if you're on Zoom, please unmute and state your full name.
We do not have him checked in.
Yeah. I don't have any explanation for that, Judge. I gave him all the notices, was texting him, going back and forth. I don't have an explanation for why he's not here.
All right. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500. Give a 10% privilege. That warrant will issue immediately.
Thank you, Judge.
Your Honor, I apologize if I can step in. My understanding that was set yesterday for a preliminary exam where the court issued a bench, where the court indicated a bench warrant would issue on June 22nd. I don't know if the court wanted this bench warrant to issue that same date or if the court still wanted to issue it immediately, but I want to that other.
Yeah, I'm going to issue this one immediately only because he had a previous bench warrant on this case and hasn't appeared.
Okay.
Okay. All right. Well, thank you for that. Court does call the case People versus, is it Abdurrahman Banda?
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Bonda.
Banda?
Bench
warrant will issue for defendant's failure to appear. Bond will be set in the amount of $7,500 for 10. That warrant will issue immediately, along with the other three. Court calls the case of the People versus Paris Calloway.
Morning, Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Paris Calloway.
What?
Good morning, Your Honor, Paris Calloway.
All right, thank you.
Your Honor, Mr. Calloway, since we've been court has had a driver's license restoration hearing. He just took the written and the driving test. He's asking for an adjournment in early July. Is that correct, Mr. Calloway?
Yes. Adjourn the matter to. Is that too early in July or?
Is that enough time, Mr. Calloway?
Just a little bit in the middle is okay. If I can get like towards the middle, just to make sure I got everything done.
Adjourn the matter July 15th, 2026, 9 a.m.
Thank you. Thank you.
Thank you. Thank you, Your Honor. Have a good one.
Thank you. My goodness. Court calls case People versus Nicole Coleman.
Ron Brown appearing on behalf of Ms. Coleman, Your Honor, who's making her way to. Please state your name.
Nicole Coleman.
Your Honor, is the court in receipt of a waiver of trial by jury?
I am. Ms. Coleman, you're waiving your right to a trial by jury. All right, you understand that you have an absolute constitutional right to have the matter tried before a jury? You understand that by doing this, you're giving up that right to be tried before the court without a jury. All right. People also waive the right.
Yes, Your Honor.
Based upon the statement of counsel, the defendant court will consent to have the matter tried before it without a jury. Non-jury trial in this matter will be set for
June 24th.
Your Honor, may I approach with the prosecutor very briefly?
non-jury trial in this matter will be set July 29th, 2026, 9 a.m. in person.
Thank you, Your Honor.
All right, thank you. This is another one. Court calls case People versus Shamika Kurtendahl.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Ms. Kurtendahl.
Ma'am, state your name.
Shamika Kurtendahl. Good morning.
Good morning.
Your Honor, may I have an adjournment in this case?
In the matter July 1, 2026, 9 a.m. Bond continued. Court calls case People versus Ishmael Davis.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Davis. Please state your name.
Ishmael Alexander Davis, sir.
All right.
Your Honor, Mr. Davis has several other matters pending. We're trying to resolve it by global resolution. I've been in contact with the prosecutor.
I don't know if you wanted anything from me on that. That is correct. We are in communications about a global resolution.
So what do you want me to do?
Adjourn, please.
Were you in treatment, sir?
Yes, I was in treatment, then I was sent to outpatient, and now I'm back in outpatient. And I'm almost, well, July 21st, 5th will be 12 months I've been sober.
Congratulations.
Yes, sir.
Just I'll adjourn this to July 15th, 2026, 9 a.m.
Thank you.
Court does call the case People versus Martasia Davis.
The people.
Assistant Public Defender Nick Bukovich on behalf of Davis, who should be appearing via Zoom.
He's here. She did not check in, but I see her name. Davis? Artasia Davis?
Hi, this is my. Sorry.
State your name.
Martasia Davis.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of retail fraud in the second degree, the 1-year offense, which is as charged. And that there is a sentence agreement to HIDA.
That's correct, Your Honor.
That's correct, Your Honor.
All right. Ma'am, can you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record.
Martasia Davis.
Ma'am, you can put your hand down. It is this court's understanding you're going to plead guilty to the charge of retail fraud second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Do you understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
All right. You had signed or had somebody execute an advice of rights on your behalf. Is that correct?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
No, Your Honor.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
Understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes.
And let me find my complaint. If I can. I think people. Hold on one moment. Where they put it? On the date of January 2nd, 2026, at the location of 2000 Waters Road, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do at the Target store that makes you think that you're guilty?
I shoplifted items from Target while it was open to the public.
Okay. All right, you went into Target, is that correct?
Yeah.
You took some items that they had offered for sale?
Yes, Your Honor.
And then you tried to walk out of the store or did walk out of the store without paying for those items?
Yes, Your Honor.
And it's not value. And was the total amount of the items that you took in excess of $200?
The total amount?
Yes.
Like, of how much we took, I would say.
Your Honor, we would stipulate to the report it would be a total of $334.
$334. You have any objection to that stipulation, ma'am, or agreement that that's the amount that was taken?
I agree, Your Honor.
All right. Ma'am, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, that you would not be entitled to any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Parties aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
The defense is satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to this charge. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 22nd, 2026, 9 a.m. Bond in this matter will continue. Ma'am, I'll ask you to remain on the line. We're going to put you into a breakout room with my probation department so that we can begin that process.
Okay.
Thank you.
Your Honor.
Court calls the case, People versus Grant Garcia.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown, I'm appearing on behalf of Mr. Duche, is it?
Jay, that's right.
Morning, Your Honor.
Good morning, sir.
Your Honor, I'm requesting an adjournment of this case.
Your Honor, it's called appropriate.
Yes, why don't we address bonding?
Your Honor, I'm going to be asking that the court raise bond to an amount of $5,000 cash or surety on this case. As the court is aware, the defendant failed to appear, I believe, back in February for this pre-trial, as well as a felony matter that was set for PCC. In the time,
Mr. Bates.
In the time between then and today, the defendant has picked up 2 new felonies for retail fraud in the first degree. I authorized this just recently. I believe they've been sworn to, but those have been authorized are coming down the pipeline shortly. Those are, in all candor, both based on priors, not values. So it's not more than 1,000, it's between 200 and 1,000. But because it's prior retail fraud convictions, that makes those into felonies. I have concerns in that he's committing offenses while on bond as well due to his previous failure to appear. That PR bond is no longer appropriate, and so I'm asking for a $5,000 cash or surety, or in the alternative, if the court's not willing to grant that, a GPS tracking tether.
Your Honor, may we have the offense dates for the new charges? I'm trying to make sure that they aren't covered while he was on bond for these cases.
Let me one was February and one was April 22nd, both of this year.
February 10th,
And April 22nd.
he was on bond, and one of them he allegedly would have committed while on bench warrant status in this case.
So would the court consider 2,500, 10%?
No, right. I think it's appropriate that it's a $5,000 bond in this case. I'll adjourn it to my next date of July 1st, 2026, 9 a.m. Bond is raised to $5,000. You were requesting cash surety,
Correct, Your Honor.
$5,000 cash surety.
Have to go.
Pending it's remanded.
Gotta go with the option.
Go with him. Court does call the case, People versus Nathaniel Flanagan.
Ron Brown appearing on behalf of Mr. Flanagan.
Yes, sir. I'm here. Your Honor.
All right, I need a camera.
Oh, sorry. Here we go. I'm sorry,
All
Your
right.
Honor.
It's all right. State your name.
Nathaniel Flanagan. Nathinel Flanagan. Flanagan.
All right, thank you. All right, what are we doing?
We'd ask the court to set final settlement and jury selection date.
Jury final settlement conference in this matter will be set for August 7th, 2026, 9 a.m. Jury selection, August 10th, 2026, 8:30. Both of those proceedings are in person. Bond will continue. Thank you.
Okay, thank you, Your Honor.
Thank you. Court does call the case, People versus Angela Hayes.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Ms. Hayes, Honor.
Where is she? Hello,
here.
Ms. Hayes. Okay, can you turn on your camera?
It is on, it's not working.
Okay.
We'd ask the court to set final settlement jury selection.
You recognize the voice.
Yes, sir.
Jury final settlement conference in this matter will be set August 7th, 2026, 9 a.m. Jury selection, if necessary, August 10th, 2026, at 8:30. Both of those proceedings are in person.
Thank you.
Court calls case People versus, is it Jeter Ivachek? Messed it up.
Yes, Your Honor. And Assistant Public Defender Nick Bukovitz on behalf of Mr. Ivazov, who is appearing via Zoom.
Ivazov? I think it's actually Peter. I don't think the J is. Okay.
So you should see a little button with a little microphone on it on your screen. If you tap that, you should be able to be unmuted. I do know I spoke to Mr. Ivazov this morning, as well as a friend who was helping him get on the Zoom. So I do know he did log in and get on today, but I do know he might have some issues with the Zoom technology.
You prompted him. See if somebody, I'll pass it, see if somebody can call in.
Yes, I understand. Thank you, Your Honor.
Court does call the case People versus Spencer Rassick.
Your Honor, Raymond Cook for the people. I just spoke to my wife going inside vestibule, so I'll grab him.
Yeah, but I can't do anything. Mr. Cook left.
Hello.
Oh.
Hello.
State your name. Okay. Do you have a camera?
I do have camera, but I don't know how to turn on. It's new for me right here. I don't know. It doesn't know.
You recognize his voice? Okay.
I spoke to this morning, actually.
All right. What are we doing?
I would be asking for an adjournment to work on obtaining to mitigate works toward a possible global resolution with this and this matter at PCC tomorrow.
He's got a PCC also.
Yes, he does.
July 15th, 2026, 9 a.m. Bond continued. Thank you, sir.
Thank you, Your Honor. Have a good day.
You too. Court calls case of the recall the case of People versus Brianna Force.
Morning again, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Miss Brianna Force. She's present on Zoom.
Yes. Ma'am, can you state your name?
Brianna Force.
All right. Okay, what are we doing, Miss Barnwell?
We're moving forward with the case, Judge. So I think it's a pretrial or final pretrial, maybe?
Well, let's see. She had a non-jury trial set for July 20. Oh, that was way back. All right. So you want it set for a final pretrial?
Yes, Judge.
Jury final settlement conference will be set August 7th, 2026, 9 a.m. Jury selection, if necessary, August 10th, 2026, at 8:30. Both of those proceedings are in person.
Oh my goodness.
All right. Oh.
Judge, for the August 7th, I'm in Lincoln Park. Is there any way to get that?
No, it's the only final settlement conference I have for about a 2-month period.
Oh my God. Oh, sorry, I was looking at July. Good. August 7th is a good day. Sorry.
Okay. All right. We'll see you then.
Thank you, Judge.
Thank you. Bond continue.
Thank you.
August.
Court
All right. Thank you, Judge.
Mm-hmm. Court recalls the case, People versus Spencer Rassick.
Morning again, Your Honor. Just grabbed him. He was here. Then he
David, wait. That long, but everybody's. Is he with his client?
yes.
Is he planning on showing up today?
I don't know if I can testify today.
I'll tell him I'm not gonna keep waiting. He'll get called up in the next block. Court's gonna stand in recess.
Oh,